Attorney General Mike Cox is one of the 13. Sir, it seems to me interesting that 12 of you are Republicans and
Right.
4 of you are running for governor. Is this politics? 4 running for
Chris,
governor.
I am running for governor, and Nancy Pelosi is running for her seat, and Harry Reid is running for his seat as well this year.
Yeah, but you're trying to get a promotion based on this suit. Let me ask you this. Do you really believe it's an invasion of the sovereignty of the state of Michigan? That's what the language used by Bill McCollum down in Florida. He's run every 2 years for something or other since I can remember. Go ahead.
Yeah, Chris, what we're arguing is that the federal government has never, Congress has never said to Americans that part of the price of being an American citizen is that you have to buy something. And here, for the first time ever, we have to buy something. We have to buy health insurance or the federal government is going to fine us. That has never happened in our 200-plus years of history. And we're saying Article 1 of the Constitution doesn't authorize this.
Well, let's take a look. Okay, Article 1, you're going on. Let's take a look at the Justice Department spokesman. He just put out this statement tonight. We will vigorously defend the constitutionality of the health care reform statute, along with any other claims in any litigation that is brought against the United States. We are confident that this statute is constitutional. We will prevail when we defend it in court. What is your sense, Attorney General, Mr. General, I should call you, about the possibility of you winning this case? I mean, I talked to Pete Williams here, who's a pretty straight down the line reporter on this, who knows his stuff. He said there's a possibility that you might have a case. It may be remote, however. What's your sense of the plausibility of you getting cert, going to the Supreme Court, and winning your case with a 5-4 at least decision?
Well, Chris, I think we have a very strong case. As I said, in the past 15 years, the Supreme Court has scaled back Congress when they've tried to inject themselves into purely state matters and using the Commerce Clause. A perfect example was the Morrison case with the Violence Against Women Act. Another case was Lopez, where they tried to criminalize purely state behavior within a state. So this, over the past 15 years, the Supreme Court has scaled back and said to Congress, when you try and go after activity that doesn't cross state lines, and when you try and go after activity such as here, which is inactivity, here, the federal government is punishing people for not buying a product. They're punishing them for not getting into interstate commerce, and that has never happened before.
Well, they punished people in the Civil Rights Act under public accommodations in 1964 for not selling to an African American who comes to a hotel door and says, I want a room. So there you have them punishing a hotel owner or a restaurant owner who's running a diner. If you say to a black fellow who comes in the door, get me a coffee, and you say no because you're black, that's the Constitution held that they had the right in Congress to do that. So how's this different?
Well, Chris, that
was interstate commerce.
Well, that was apples and oranges. They were proceeding under. They were proceeding under the 3 amendments that came into being after the Civil War.
I'm following your language. They said you must sell
let me finish, Chris, if I can.
To this fellow.
But here's the difference. The federal government wasn't saying there to the individual who wanted to use the hotel room, the African American, you have to go into that hotel, that public accommodation, and make a purchase. Here, the federal government is saying you have to go into the public square, the public marketplace, and you have to make a purchase of health insurance. That has never happened before.
But you do recognize that the opposite was done, that they said to the hotel owner, you must sell the room to this customer if he's a legitimate customer. You do understand the government, the Congress of the United States went across all state lines and said, I don't care if you open up a Mrs. Murphy's, I don't care if it's a corner store that only sells the tomatoes they cooked, they grew out back. You must sell those tomatoes to anybody who comes in the door. You must sell them. So you understand the strength of that Interstate Commerce Clause as invoked by the Congress in the past and accepted by the courts. You understand that?
Absolutely. And so if an insurance company turned down someone because they were black or because they were gender, that wouldn't be allowed. Right. But this is not the case. This is where the federal government is saying, you have to buy this. You can't be a cash payer for health care. You can't make private arrangements with your insurance company. You have to buy this.
And by the way, you think hospitals should have to take care of a person who's killed in a traffic, taking care of a person who's injured in a traffic accident, right? They must take care of them, right? That's a law.
That's a federal statute,
the law.
Yes. Yes.
Okay, thank you. So I'm looking at the other way, which is you have to help contribute to the cost of your medical care if you expect it in extreme cases to always have somebody pay for it. Whether it's a traffic accident, a heart attack, a stroke, you expect somebody to come to your aid without cost if necessary, right?
Well, Chris, almost 9 out of 10 people have insurance companies and have a contract with insurance companies to take care of that, or they pay cash.
Right. Well, the government's going to try to say make it 10. Anyway, it's a good case. It's an interesting case. Let's put it that way. Good. I'm not going to say good luck with your case, but we'll be watching you. Thank you, Attorney General Mike Cox of Michigan, state of Michigan. Well, Congresswoman Donna Edwards is a Democrat from Maryland. Congresswoman, you're an attorney. You know the law. You're